judges.
We are currently joined by our Radio 97 lawyer, Despina Priala of Priala Legal. Now, we were talking a $40 million waterfront windfall. What's all of this about? I'm excited.
Yes, the article was published overnight in The Australian. I love reading The Australian. It's got some very good, interesting stories, very noteworthy stories. So this was one that came overnight, and it involved a waterfront harbour view property in Sydney.
Ooh, nice. Yeah.
So that speaks dollars straight away,
Cha-ching.
doesn't
Yep.
it? Yes. So what happened in this particular case, apparently, and I have not read the actual case, so this is a snippet from The Australian, and I do intend to read the case in full, and probably will do that between now and next week to get some more details for the listeners. But a Sydney couple will actually inherit their neighbour's property after a bit of a battle through the New South Wales Supreme Court recently, or I'd say over the last year actually, now it's been reported. So what happened was this particular couple bought, as they reported here, the worst house in the best street.
Oh, that's the
Of
way
course.
to go, isn't
Yeah,
it?
it is, isn't it?
Yes,
Yep.
and they intended to renovate it 100%. That was the whole purpose of buying it. So you've got the great water views, but it's a pretty awful house.
Shabby.
And we've heard these stories before. Great, I'm going to renovate it, no problems. Now, when they started to talk to their neighbour about it, and that must have happened over the period of time because of this case, the neighbour, an elderly lady, said, please don't renovate, you're going to block my views. And, well, you can imagine if you bought a property to renovate, and the neighbour says, well, don't do it, then you're sort of, well, what do we do? So apparently the elderly lady said, well, if you don't renovate and leave it as it is, which means I have unimpeded views still, and I will stay here till the day I die, because she was elderly and I don't want to move into a home. I want to keep my home and live in it till that point, which is always preferred.
Yeah.
Then I promise you that I will give you this property if you don't renovate yours, so I can stay here.
So they could stretch over the two pieces of land?
Well, no, that property that was hers, she apparently promised to give her neighbour the property when she died. So that's why they call it a big windfall, and they've headlined that because this particular couple have actually won in the Supreme Court, and it's been awarded that they actually receive this property after a bit of dispute with the deceased siblings over a period of time.
It seems that the problem might be that there was nothing written down.
It was
Would that be
not.
correct?
So it's only a verbal agreement.
That's right, it was a promise.
I don't know if you can ever go
not
on
worth
that
the paper
promise.
it's written on. Yeah.
It could
Yes.
be an empty one at that.
I think there'll be a few twists in this case once I read it, because when I've just read the article overnight, of course, and wanted to tell the listeners straight away. It's a very interesting story of another estate litigation case, and a lot of money here, particularly, is that it did come down to a promise, apparently. So the neighbours gave evidence, of course self-serving, that, well, we spoke to our neighbour and she promised us that we would have her property when she died if we undertook not to do the renovations as she wanted. So it was a promise, not in writing, of course, just a verbal promise. Now, when she passed away, it says in the article they were very, very surprised that they were not named as a beneficiary in the will.
So they get nothing?
They got, well,
At the time?
the original will, they were not left with anything, and then she made a codicil, which was a change to the will before she died, and left them only, I say only, $25,000.
Ooh,
Still
that's a big
nice,
difference. Yeah,
but-
that's not the millions they were hoping
No,
for.
not the
Exactly.
right
No.
So they took it to court in the Supreme Court and had to make a claim because they were only left $25,000, and that's what you do if you want to try and obtain more than what you perhaps were given under a will for a deceased estate. You've got to make a claim, and there are certain time periods to do that. So this is what they did. They embarked on a claim, and they had to deal with the deceased siblings, who were the named beneficiaries in the will. And the interesting twist here is at the end, the property was awarded to them, supposedly based on this promise. But at the end of the article, it mentions that the two siblings who were the beneficiaries, in addition to some charities, which was interesting as well, actually died. And so did the deceased's lawyer, who was looking after the matter. They all died before it completed.
So the neighbours were next in line?
Well, apparently so. So I dare say that if they had not died, then it might have had a different outcome, might have. So that's why I say there's a few interesting twists. But what comes out of this is that the court was prepared to listen, of course, to a claim where a neighbour said, look, it was promised to us and I want the estate to fulfil that promise because we in turn chose not to carry out certain actions based on that promise, and it was a very real promise to us, and it had certain ramifications, I'm sure, because they decided not to undertake the renovations, not to spend the money, and then maybe they were intending to sell it and profit.
I know they eventually won in this case. However, you say the outcome could have been different. I guess purely from a legal standpoint, you would say get that in writing, wouldn't you? When you're talking about potentially $40 million, you really should have it in writing, shouldn't you?
You should, but then to do that invokes a lot of different things, doesn't it? Because then you've got to sit down with the person and say, well, you promised, so let's put it in writing. And then once you start to ask that person to do that, they may not be inclined to do it because then they have to say, well, I'm really committing here to put it in writing. And not everybody wants to do that. So it's one thing to promise verbally, it's another to commit in writing. Both have always been recognised as contracts by the courts over many, many years. So verbal agreements are contracts as well as written agreements. But the difficulty with verbal arrangements is that it's evidence. He said, she said. So the court did say in this case, isn't it interesting that the neighbours, of course, gave very self-serving affidavit material to bolster their case? Well, naturally, they're going to do that. So had there been someone else in the wings to counter that, had there been someone else in the background to say, well, that's not what I heard a different story, here's my affidavit, I dare say it would have had a slightly different outcome.
Meaning family members?
Exactly.
So did the neighbours try and convince them to, when firstly we saw that will come out, was there any way that the neighbours were saying, hang on, it's not yours to the siblings before they passed?
Well, actually, the neighbours drove all the way up to Tweed Heads and Ballina, which is just next to us here in the studios, because that's where the siblings lived, and a brother and sister. And they appealed to them and said, look, this is what your sister, the deceased, promised us, and we're coming here to try and talk about a redistribution of the estate, and that was flatly refused. Yes.
So
I like
maybe
that
they
too.
wouldn't have backed down if it wasn't for the inevitable that ended up happening.
Well, perhaps, but 10 points for effort to try and do that. And that's sort of along the lines of what I've talked about in the previous weeks about communication and, you know, being open with people and saying, look, this really happened. Yeah. What do you say about that? Well, they can either say yes or no.
That's true.
Yeah, so at least they made the effort, but they had to go to court in this case, and of course the value of the property really justified it.
Yeah, well and truly.
So did they move into the old house, lived there until they upgraded to the new one?
No, they actually. Yeah.
Sorry, I missed that bit.
I don't know.
Oh,
that's the thing.
so sorry.
No, we'll leave that
So
out. That's
sorry,
fine.
because
Leave that out
That's
because
good. We're getting to time anyway. So
yeah,
that's,
I
that's
don't
enough.
know.
Yeah.
All right,
Yeah.
okay.
No, so we'll leave it at that anyway. All right, so we'll just finish it off. Yeah. Okay. All right. So, was there anything else you wanted to add?
No, just if you're going to finish it off, just to say that. So if you are interested in making a claim, go see a lawyer because there's time periods. I was just going to say that.
All right. Yep. So once again, the advice is, if you're interested in making a claim, you really should go and seek legal advice.
Absolutely. So in New South Wales and Queensland, both states, there are time periods from the date of death to make a claim. So you can't leave it forever in a day. If you genuinely believe that you have a claim to make and that you are owed something or more than what you were given in a will, go see a lawyer as soon as possible, because there is a lot to discuss and a lot to iron out and a lot of information gathering that has to take place.
All right, well, you have brought us lots of information this morning, and there's so much more we could have done, but unfortunately we're running out of time. However, if anyone has a question, legal question regarding real estate or anything else that's been bugging you that you would like some free legal advice on, then Despina is always here on a Thursday, happy to help out. Just send us an email with a few details in it at breakfast@radio97.com.au.
And you can also be found at Cockle Shop. Can you give your address too at the end? Sorry.
Yes.
So how about we say, and we can also find your boutique law firm up in Runaway Bay.
Absolutely, 49 Cockleshell Court, Runaway Bay, and of course our website, prialalegal.com.au, and they can phone the office 55 291 294.